Welcome, everyone. My name is Andrew, and I am here today to continue our Florida Bar Complete course, and we're working on the February 2025 bar exam. Time has moved on, just as it always does, and here we are, just you know, about a month and a half, maybe 2 months, maybe 7 weeks away from the bar exam. Definitely a good window to lock in, as the kids say these days. So let's lock in on some real property Jeopardy, Florida Jeopardy. And can you all see my screen?
Yeah.
Why you say it so unenthusiastically?
Yeah.
Oh, nice, nice. All right, cool, thanks. Okay, let's do some easements. So an easement that is in writing.
Express. No.
Yeah, I like that. An express easement. I think that's the answer. Yeah. Say with some more confidence, more enthusiasm, more confidence. Enthusiasm, confidence. I'm a cheerleading coach. Okay, when a property owner needs to cross over another property in order to access a public road.
What is easement by necessity?
Yes, that's so good. Similar to adverse possession without exclusivity.
Prescriptive easement?
Yeah,
Prescription?
easement by prescription. Good job, Sean. You stole. That's she
I did
needed.
not intend to steal anything. I'm
No,
sorry.
she needed. No, there's nothing.
I
There's
didn't
no.
know it. I didn't know
There's
it.
no thunder to steal right now. Okay. An easement by utility company, for example.
Easement in gross.
Easement and gross, exactly. Good job, Grace. Easement and gross, right? Like it's personal in nature. The only type of negative easement recognized by Florida. Do, do, do. Where's the enthusiasm? What do you have now? What is that pink thing? Is it
Fifth?
vape? No, never mind.
Oh, it's a marker.
Oh, it's a marker. It's a marker. Okay. Nobody knows.
Is that an easement
Okay,
by express grant?
So what is a negative easement? Let's piece this question. Let's deconstruct this question. What's a negative easement mean?
Covenant.
Well, like an affirmative
What's-
versus negative easement. Affirmative means that like you have a right to cross or a right to, use. What is a
It's
negative
like you
easement?
can't do something on your own property.
Is the right to prevent the land or?
Prevented. So, okay. Does anyone know the case of the Fontainebleau versus Eden Rock, the spite wall? My grandfather was around for that case. He used to tell me about that like back in the day. So yeah, what happened? Fontainebleau built a tower that blocked the sun from the Eden Rock pool, and Eden Rock was pretty upset about it. But they determined that they didn't have a right to sunshine, right? There was no negative easement there. You don't have a right to a view. You don't have a right to air. You don't have a right to light. Is there any negative easement that is recognized, that you do have some right where people can't really infringe upon your right of use?
Is it like a water right?
Yes, sir. Water right. Yeah. And what's the more
To view to water.
Water,
Is
yeah.
it easement appurtenant? Is that what
No,
it is, or like your riparian rights or something like
it's gonna
that?
be
or-
riparian rights. Yeah,
Okay.
Oh,
yeah, a riparian easement, right? That's a water right in Florida. That's a cool little conversation we just had right there. You guys enjoyed that? Like in Florida, we don't have a right to air or sunshine. Like I see this happen all the time. I live in Coconut Grove and it's happening. Where there'll be a building that has this really great view, and then there'll be another building that's built right in front of it, and the people are like, oh man, that sucks. Like you had a view and now you don't have a view, and there's really no recourse because you don't have a right to a view. That's not a negative easement that you do have, but you do have this riparian right where it's like, reasonable flow, prior use. They can't like reasonable use. If you have, you live on the water, they can't dam up the river and stop your flow, right, of the water.
Wait,
Go ahead.
maybe another person buying a house couldn't do that, but could the city do that? Or would it be
Taking though, wouldn't it?
Yeah, I don't think they could that easily. I mean, again, the city may be able to, but they might have to provide compensation for that. I would think that would be the argument I would make, that if the city interfered with your prior use of water rights, they would have to provide just compensation. Like, wouldn't you be kind of pissed if you had a little boat and then one day the city was like, oh yeah, sorry, we're damming this up. Like, peace be the journey. You probably would get some form of just compensation. I don't know, but it's an essay question that you could, write about. Certainly, it would be easier for the government to do than for your neighbor Johnny. But I still think that the government would have to there would be some form of recourse in the form of condemnation or eminent domain. Okay, let's talk about two. Topic two. Let's talk about topic two. This mortgage has super priority.
Purchase money.
Mortgage,
PMI,
What did you guys say? Yeah, PMM.
money mortgage.
PM
Purchase money mortgage. Super. I don't know if you guys know that movie. That's an old school movie. PMM, purchase money mortgage. You guys don't know what that means, a purchase money mortgage?
Yeah, it's when you get a loan specifically to buy that house.
Yeah, exactly. And so if there's a foreclosure sale, then they're gonna have priority because it's like, bro, you wouldn't even have the house if it wasn't for us, the bank, having lending you the money.
Mhm.
A forced sale to pay off a mortgage. I kind of just gave that away.
Sure.
Foreclosure, yeah, I like the enthusiasm. What is a foreclosure? An action when the foreclosure isn't enough to pay for the mortgagor.
Um,
I'm gonna make this make more sense to everyone. Okay. An action when the foreclosure isn't enough to pay off the mortgagee.
Yeah, the chat, it's saying deficiency.
Yeah, deficiency judgment, exactly. Exactamente. A deficiency judgment, because that is a keyword that y'all should know that, like, okay, so there's a mortgage, right? A buys a home and takes out a mortgage, right? And B and C both lend money, or B is the purchase money mortgage, and C is like someone who lends money and takes out a mortgage on the property. So the B and C both have mortgage on the property. Now A defaults and doesn't pay back B. So B institutes a foreclosure sale, right? So when there's that foreclosure sale, there's going to be a senior and a junior mortgagee. The senior mortgagee will be the PMM, the purchase money mortgagee, and the junior mortgagee will be C in this scenario, right? Is everyone with me so far? B, the PMM is the senior mortgagee, and C is the junior mortgagee, right? Okay, so now the sale occurs. Well, unfortunately, it was bad market conditions. It was like, Jimmy Butler just left, and why do I keep forgetting Cheetah's name? He's already gone. He's already ran fast from my mind, but he already left too. What'd you say? Harry Hill, yeah, he left too. So like everyone's leaving Miami. So the market has gone down. So now the sale of the house isn't enough to pay off the balance for the mortgagees. Maybe it pays off the first mortgagee, but it doesn't pay off C. Or maybe it doesn't even pay off B, right? Then how would B and C collect from A? Does anyone know? What would they need to seek? There's a chance. Yeah, I was gonna say there's a chance it's written on the board right now. A deficiency judgment, right? That's what that's called. A deficiency judgment would mean they need to collect personally from A. Does that make sense? So A is the mortgagor, B and C are the mortgagees. There's a foreclosure sale. Tyreek and Jimmy and all of Miami have ran out of town, so the housing market is down. The sale of the house is not enough to pay off the remainder of the mortgages. So now B and C need to collect personally from A. The way that B and C will collect personally from A is known as a deficiency judgment.
Yeah.
Yeah, exactly. No, this is like an important word. Okay, so Florida is this type of notice jurisdiction.
Pure notice.
Pure notice, exactly, as opposed to what?
Race
Uh,
notice or race.
Yeah, as opposed to race notice or race, exactly. So what does pure notice even mean? One would ask.
That it's the last, so like the subsequent bona fide purchaser. So someone who purchases it without having notice of prior records, or like of somebody else having a lien on the house, is the person to have I guess, title.
Yeah, the subsequent bona fide purchaser will prevail.
Yeah.
Let's use that language. In a pure notice jurisdiction, subsequent bona fide purchasers will prevail. In a pure notice jurisdiction, subsequent bona fide purchasers will prevail. What does that mean? What's a bona fide purchaser?
Someone who
Someone that pays
gives
money
value
for it?
without notice of a previous or like of a competing claim for the property, whether it's actual or constructive notice.
Exactly. Someone who takes for value without notice and in good faith. And that begs the next question. What is notice? And you just said that notice could be actual notice. Like, I know that Tommy has a farm on the property. Notice could be constructive notice in this form of inquiry notice. A reasonable inquiry of the property would have shown you that Tommy had, an operation going on, or record notice that it was recorded in the county records, and you just had to, look up the records. So those are different forms of notice. If you have notice, then you're not a bona fide purchaser because, you should have known. And then if you didn't take for value, you didn't pay money, you're not a bona fide purchaser because you didn't pay money. Now you can take shelter in the upstream status of a bona fide purchaser under the shelter rule, and that's someone who maybe didn't pay money. They were gifted the property, but they were gifted the property by a bona fide purchaser, which would allow them to take shelter, upstream shelter in the status of the bona fide purchaser. So what was this conversation all about? Florida being a pure notice jurisdiction, which protects subsequent bona fide purchasers. So the last person who takes the property for value without notice is going to prevail. What does without notice means? They didn't have actual inquiry or record notice. Fair enough?
Yeah, wait, Andrew, what was it? Like the person who inherits it, what's the keyword?
The shelter rule.
Yeah, thank you.
Shelter rule. Yeah, you can take shelter in the upstream status of a bona fide purchaser.
Hey,
You guys
Andrew,
all- Go ahead.
what happens if said person who took shelter, because I think it's happened in a couple of property essays or questions, who took shelter then decides to give the property or sell the property themselves, to the subsequent person, I guess the third person, does the shelter rule continue, or does it not?
Wait, can you say that again? I'm sorry.
No, sorry. If someone, who wouldn't otherwise be a bona fide purchaser, but because of the shelter rule, they're okay. But they themselves then want to like gift or
Yeah.
sell or something to a third person. What happens then?
Yeah, they could. You could take upstream shelter, double shelter is what you're
Right.
saying. Like a gift and a gift. I buy the property, I'm a bona fide purchaser. I gift it to Tommy. Tommy takes shelter. Tommy gifts it to Johnny. Johnny takes upstream shelter in my bona fide purchaser status. Yeah. Until there's a new bona fide purchaser, all of these people can take upstream shelter in my status as a BFP. That's some pretty important stuff. I think mortgages are actually a key to the bar exam, right? Mortgages on the MBE and mortgages in Florida. You really have to understand what is a mortgage, how a mortgage operates, and a lot of like considerations about mortgages. So you can ask away this class for sure. Under this theory used in Florida, a mortgage by one tenant will not sever the JTROS. So what theory is Florida? What state? I think someone put in the chat.
Theory.
Yeah, lien theory.
Lean
Well,
theory.
a lien theory, yeah, exactly. A lien theory, meaning that when someone lends you money, or there's a mortgagee, right? Someone lends money and takes an interest in the property. That person does not take title of the property. They just have a lien on the property. Where some states, they actually take title to the property. And if they took title to the property, it would sever a JTROS. So if you're writing the essay that's assigned, this is important, right? Like if Tommy and Johnny have a JTROS, right? And Johnny takes out a mortgage but doesn't tell Tommy, will that interest sever the JTRS? The answer is no. And what's the implication of that? Well, what if, so Tommy and Johnny have this JTRS. Tommy takes out a mortgage. Tommy dies. Can the mortgagee collect from, I forget which time you're Johnny. A and B are partners, B dies. B took out a mortgage. Can the mortgagee collect from A? The answer is no, because it's a lien theory state. If it was a title theory state, the answer would be yes, they would have title to the property. But under a lien theory state, the death of a party will not allow the mortgagee to collect from the property. They would have to collect from that party's individual estate, right? Okay. What is lien theory? A right of access to all governmental proceedings. This should be an easy question by now. Wait, this is a common law question.
Sunshine law.
This is a common law question. I think we're merging into common law, but let's just see what we got here. Sunshine law, right? These are common law questions. Tricks, yeah, gotcha. Applies to half an acre inside municipality and 160 contiguous acres outside municipality.
Homestead.
Homestead, look, you guys know all this. Gives municipalities the power to enact ordinances that do not conflict with the Florida Constitution.
Home
Rule.
Power,
Almost.
yeah. Wow, y'all are doing well. Must be approved by a referendum of the majority of electors.
special.
Special law.
Yes. Special law, or I think this could be like a change to the Constitution, like let's see.
Like an amendment?
Yeah, I guess amendment would be like a 2/3 law. So you're right, special law. All right, you guys are right. I was wrong. Access to courts, for example, may be overridden for public necessity.
Kluger doctrine.
Kluger.
Yeah, Kluger doctrine. Excellent. All right, so this guarantees the freedom of speech and religion, for example.
The extra.
Person.
Oh,
Yeah,
First
Amendment.
Amendment.
The government must give just compensation.
Taken.
Eminent domain takings clause. The government shows necessary to achieve a compelling interest.
Strict
Strict
liability.
scrutiny.
Strict scrutiny, yeah. Laws cannot punish people retroactively.
Ex post fact. Ex post.
Ex post facto. The federal government cannot compel states to enact legislation.
Commandeering. Anti-commandeering.
Yeah, anti-commandeering clause. So this is back to real property. Tenancy for a specified period of time.
yeah.
Tenancy for years?
For years.
I'm not sure how I've never fixed that. Tenancy for years. Yeah, for sure. Unauthorized improvements to a property by a tenant or life estate holder.
That could be ameliorative.
It could be.
It's a waste.
It is. Put those two together and you have ameliorative waste. A purchaser who takes for value in good faith.
BFP.
Yeah, bona fide purchaser. A concept where the risk of loss passes to the buyer after contract but before closing.
Risk of loss, and then it's. Is it
Bubble something?
Equitable something, yeah. See in the chat.
Stubble.
Is it equitable title?
Echo conversion, yeah. You know, that's from Rob Deerdeck. Yeah. Okay, 7 years. I think that's the time for adverse possession.
Yes, I think so.
Yeah.
Time for adverse possession.
Wait.
All right.
Wait, I have a question.
Go ahead.
Yesterday, John Grossman said it was 20.
That's for prescriptive easement in Florida.
Okay, so
7 years for adverse possession, 20 years for prescriptive easement. Yeah. There are some essays where they say 20 years, but those essays are wrong. Remember, the Florida essays aren't edited, but it is 7 years for adverse possession, 20 years for prescriptive easement. All right. What about commercial paper? What do you guys know about it? It's gonna be a hard question. This requires the same elements as a BFP.
Holder in due course.
Nice, a holder in due course. Does that make sense? Like a holder in due course without notice for value in good faith, and then it also consider the shelter rule. So that was pretty cool. I think y'all had a pretty good showing there. What do y'all think? Pretty solid. Okay. I think this is one of my oldest PowerPoints. Yeah, this is one of my oldest PowerPoints from 2021. Damn. Been in the game for years. All right, so Florida bar crash course. My name is Andrew. I love this. What day is it today? It is today, Squeak Piglet. My favorite day, said Pooh. The Tao of Pooh. Very important stuff, right? You know, yesterday is behind us. Tomorrow we can't control. You really want to stay present. And I think that's a pretty simplistic way of looking at it. So, at least try to lock in for the next like 30 minutes or so and try to learn from me. I don't claim to be the GOAT of this. I'm just a regular guy teaching some property. All right. So here's the outline for real property: deeds and titles, estates and property interests, joint tenancies, covenants and equitable servitudes, landlords and tenants, easements, adverse possession, homestead exemption, miscellaneous, and then a little essay writing tip. Again, this was created by me a few years ago. I'm sure I have a lot to add to this, and we'll do another lecture on Wednesday where I'll add to it. But this got the job done in 2021, so this is pretty fundamental stuff right here. Let's see, that's me. Since then, I've passed California and the UBE. I don't have a Jack Russell named Biscuit anymore, rest in peace. But I do still have Rosie, still live in the Grove. Still gang for life. All right, deeds and titles. So deed versus title. What's the difference between a deed and a title? So a deed is a document that purports title, right? If you have a deed, you say, I have deed, I have title. How do you have title? Because you have this deed. This deed gives you title. Whereas title is just a position of ownership. It's just like, you could have title by deed. How else could someone potentially have title? Does anyone have an idea?
Adverse possession.
Yeah, by adverse possession, potentially, right? Like you don't have a deed, but you still have title. How do you have title? By adverse possession. So does everyone understand that difference? Deed versus title? Okay. Color of title versus actual title. Color of title means appearance of title. It seems like you have title. Now, a good way to think about title, color of title is this, right? So like these are deeds, right? This is a deed and this is a deed. Now, both people come to court and say, I have title. Look, I have a deed, I have a deed. Well, what's up with this deed? This deed is defective, right? You have color of title. It looks like you have title, but you don't really have title because you have a defective deed. You have color of title, it looks like you have title, and you have actual title because your deed's not defective. Color of title means appearance of title, right? So color of title refers to appearance of title. However, the title possession may be adverse, or the title document, the deed is defective. Actual title refers to traditional legal title. So color of title could come up in an adverse possession claim, because if you don't have color of title, where there's no document purporting that you have title under an adverse possession claim, then you have to actually have paid the taxes over the years you've been claiming adverse possession. It's like a little nuance of a Florida adverse possession claim, but if you're claiming with color of title, then you have to have like made some sort of like improvement or enclosure of the property. If you're claiming without color of title, then you have to have done that and have to actually have paid the taxes. Again, color of title means appearance of title. So then action to quiet title, that's that like legal proceeding that determines who has title. It's called quiet title. Think about it. It's like, this person comes up and this person comes up and like, hey, we have title, we have title, we have title. It's like, shh, you don't have title. Like, right, quiet title. It's gonna quiet the people who claim to have title. I don't know how often this really comes up where people have conflicting titles in 2025, but it's a test. Okay, deed formalities. This is certainly something that needs to be memorized. In order for a deed to be valid under Florida law, it must be attested by 2 witnesses and contain an accurate description of the land and be properly delivered. In order for a deed to be properly delivered, physical delivery is not required. It's just that it has the intent to leave control of the grantor. So those are deed formalities, and it does have to be, like a land sale contract needs to be in writing, and then the land sale contract will merge into the deed when the deed is recorded, and then we'll have those different types of deeds: general warranty deeds, special warranty deeds, and quitclaim deeds, and we'll talk about them. But understand, at first you just want to determine, like, is the conveyance valid? Was there a valid land sale contract that was in writing? And then was the deed properly recorded and did it comply with deed formalities? Attested by 2 witnesses and contain an accurate description of the land and be properly delivered. Okay, recording statutes we talked about during the Jeopardy game. Florida is a pure notice jurisdiction. Under this type of Recordings Act, a subsequent bona fide purchaser without notice prevails. The order of this recording after the subsequent purchaser is irrelevant. So, big points on that. In real property, Florida, these are like key subjects: pure notice jurisdiction, lien theory state, deed formalities, key topics. Anyone have any questions about the pure notice jurisdiction element? If it was me and I was writing a real property essay and I saw, oh, notice might come up, and it usually comes up, I would try to get the points in order of like, Florida's a pure notice jurisdiction. In a pure notice jurisdiction, subsequent bona fide purchasers will prevail. And then I would define what a bona fide purchaser is. A bona fide purchaser is a party who takes for value without notice in good faith. So first piece is saying it's pure notice jurisdiction, defining that. Second piece is defining what a bona fide purchaser is. And then third piece is defining the 3 different types of notice: actual notice, inquiry notice, and record notice. I define inquiry and record notice as constructive notice. You might hear different professors say different things about these words, but I think that's the easiest way to conceptualize it. Actual notice and constructive notice are the 2 umbrellas. And then within constructive notice is inquiry notice and record notice, right? So that's kind of like the little hierarchy of vocabulary terms you can knock out when writing a Florida essay about real property and talking about pure notice jurisdiction. Pure notice jurisdiction, subsequent bona fide purchasers will prevail. A bona fide purchaser is someone who takes for value in good faith without notice. The different types of notice are actual notice and constructive notice, which includes inquiry notice and record notice. Here, Tommy likely had notice, like you can do the analysis after, but you want to get those like key points. Cool. All right, marketable title. An interest in land is not enforceable if it has not been recorded or refiled with 30 years. So, right, all title needs to be refiled or re-recorded every 30 years. That's not really what's important, what's tested. What's most important is the concept of marketable title. All land sale contracts, there's an implied warranty of marketable title, which means when you sell a piece of land, you are implicitly warranting that you're not selling a defective piece of land, right? And what would makes a piece of land defective? I think of it as like if you're buying, a TV, or you're getting a new puppy or something, new. You don't want anything wrong with it. You deserve to get, the video game that's in the box, that has the right wrapping paper, that opens up, that has the right disc in it, that goes into the game, that doesn't skip, like nothing wrong with it. So when that means in real property, for instance, is there are no easements on the property, right? Like, wouldn't it be pretty annoying if you bought you and your wife, you guys were together for like 10 years, saved up all this money, and then you finally put down in a house and you buy the house only to find out that your next door neighbor is allowed to like walk over your property whenever he wants because he has an easement, right? It's just like, man, we could have bought any house in the world, but this one has our neighbor has an easement. That's pretty annoying. An easement would make, title unmarketable. It doesn't mean that like the parties can't agree to less than marketable title. It just means that like if you don't, like that in itself makes title unmarketable. There's an easement on it. Something else that would make it unmarketable would be like a mortgage or a lien or some encumbrance on the property. Some like, there's remaining debt on the property. Now, often what happens is there's remaining debt on the property, but the sale of the property will pay off the debt. That isn't unmarketable title, right? That's still marketable if at closing, the money will be used to pay off any remaining debt. That's still marketable. But if there's still lingering debt, then that would be unmarketable. So, easements, encumbrances, mortgages, liens, threats of litigation, right? If there's some weird, like, hey, that property, someone, tripped and fell and broke their face on, there's pending litigation, that could make it unmarketable. Or if it was acquired by adverse possession, that should make it technically unmarketable. If it's a defeasible fee, right? Like But as soon as alcohol is sold on the property, it reverts back to grantor. That would make it unmarketable. If it has something called like a right of first refusal, which means like if you're gonna sell it, Tommy has the right to buy it before anyone else. Like any of these like weird conditions would make title unmarketable. Does that make sense to everyone? Okay, so we have marketable title and then a tax deed. This is actually mentioned on the essay yard assigned Florida, February 2017. It was the essay I got when I when I took the bar. And there was just this part where it's like, Susie applies for and is granted a tax deed. And I know me and everyone else in the room was like, what the fuck is a tax deed? You know, we had never studied it before. We'd never heard about it before. So I'm just teaching it because I encountered it and like, they do that. The Florida Board of Bar Examiners have a history of every exam introducing some new term that they've never told us about before. So the tax deed is just in Florida, a parcel of real property becomes eligible for a tax deed sale when ad valorem property taxes become more than 2 years past due. So if any of y'all own a house and you haven't paid your taxes, it could be eligible for a tax deed sale. Now you can go out and get a tax credit, which means you have outstanding taxes, you pay for it, you get the tax credit, and then, you know, that'll, you'll receive the deed, you'll receive the tax deed to the property. So those are deeds and titles. That's the first conversation we're having. When you read my book, you'll see that I set it out in like the land sale contract. Like, is there a valid conveyance? Is there a valid land contract that has an adequate description of the property? It has the grantor and grantee and is in writing, and then that will merge into the deed, and then we're gonna look at what type of deed it is and things like that. Perfect, types of deeds. Now, remember, someone asked me like, Andrew, how do you know that someone's ready to pass the bar exam? I said, I have a series of questions that I could ask them, and depending on how sharp the answer is, that gives me pretty good insight. This is one of them for sure. What are the different types of deeds? And then what are the 6 warranties of a general warranty deed? So the general warranty deed is the most common deed used in the sale of residential properties. The deed does more than convey fee title to the property from seller to buyer. It also provides 6 covenants of title. So the present warranties are the covenant of seisin. The seller, in fact, owns the property being conveyed, is the sole owner, and is the only party in possession. The covenant of the right to convey. The seller has the right to convey the property. And the covenant against encumbrances. The seller asserts that there are no undisclosed or non-visible encumbrances against the property being conveyed. Those are the present warranties that, you know, they could sue on at the time of the recording. After the recording, you'll have to sue under one of the 3 future warranties. And this one's actually missing the 3rd warranty, which is further assurances, but whatever. So the covenant of quiet enjoyment is probably the most common one that could be brought up, would be the seller states that the buyer's use, possession, and enjoyment of property will not be disturbed or disquieted because of a defect in title to the property. Then the general warranty, the seller will protect the buyer from harm caused by title defects and defend the buyer from any claims by others to the property's title. And then further assurances that they, you know, will provide, you know, future guarantees for against title claims. So that's the general warranty deed. The 6 covenants are seisin, right to convey, right against encumbrances, quiet enjoyment, general warranty, and further assurances. If you can just remember them, that's solid. And you want to write them down. You know, in your essays, I really encourage people to write more, to show off for the reader and show that you recognize that not only has there been a deed, but that there are 3 different types of deeds, and the general warranty deed has 6 different conveyances. Okay, the special warranty deed warrants only against anything that occurred during the physical ownership. In other words, the grantor doesn't guarantee against any defects in clear title that existed before they took possession of the property. So the general warranty deed warrants for the entire chain of title. The special warranty deed only provides warranties for the time in which the grantor had title, not anything upstream of that. It kind of brings in the concept here of a wild deed, which is a deed outside the chain of title. I mean, a general warranty deed probably wouldn't warrant against a wild deed because it's not in the chain of title, but it's like, just an idea or a concept. That's what a wild deed is, a deed that occurs outside the chain of title. And then a quitclaim deed contains no warranties of title at all. It's like a take it as you leave it. You'll see there could be like an as is sale, which refers to like the condition of the property. There could be a quitclaim deed, which refers to, title and claims of title. Florida has this concept, a landmark case in Florida of Johnson v. Davis. Johnson v. Davis is a case that says that sellers of residential real property have a duty to disclose any latent defects. So those are defects that wouldn't be, discoverable. You have a question, Eric?
Yeah. When it comes to quitclaim deeds, I was wondering if you see this on an essay, and someone transfers property under a quitclaim deed and they actually don't have an interest in the property, is it worth going down the road of doing like contract defenses to formation and saying that this contract is void or voidable due to misrepresentation by the seller that they actually had an interest? Or is there really no way? I mean, is it just something to argue, or is there really no way for the buyer in that case as the plaintiff to really pursue action against the seller?
I mean, the concept that I would talk about would be the concept of merger. Like they can't really sue on the contract once the deed has been recorded, but I would still, like you said, argue it and be like, they could argue for misrepresentation or concealment or something. However, these arguments would likely fail because the contract has already merged with the deed at this point. But the great thing about essays is just you don't get off for writing about considerations, even if it's irrelevant. I mean, it's not totally irrelevant. And I think that's going to be something that everyone will see on these essays is like, contracts and real property are going to be tested together, or like con law and torts could be tested together, family law and con law, and you don't really know for sure. They don't tell you what the title is. And then you come to find out when, they release the results, you're like, wait, there was con law on that one? And I'm like, oh yeah, because you were supposed to write about like the constitutional right to raising a family or something. Or so like, with that one, it's like, it's a real property essay, but yeah, there's still contracts, my legs, contracts for land need to be in writing. And there are contract defenses that they could bring that probably would fail because the deed has been recorded, but still worth mentioning to demonstrate knowledge to the reader. So solid question.
So the merger doctrine applies to all deeds. It's not just general warranty deeds. It's
Yeah.
any deed, even quitclaim.
Yeah, even quitclaim deed. I mean, the quitclaim deed is still going to be recorded. Just because it's a quitclaim deed doesn't mean it's not recorded. All these deeds, the assumption is they're types of deeds that can be recorded. It's just what the deeds are warranting. So, yeah. All right, let's talk about estates and property interests. So this slide I'll go over quickly because it's not too heavily tested on essays. Fee simple, even in the lack of the words to A and his heirs, a fee simple is assumed in Florida unless there are words to the contrary. A fee simple creates a permanent absolute interest in land terminable at will. So you could have fee simple absolute or fee simple, which could be defeasible, right? And there could be like fee simple subject to condition precedent, or a fee simple determinable, which would have an automatic right of reversion. They really don't test these things much on essays. This could be like an MBE thing, but just know that like conveyance, when someone gets a property, they usually have a fee simple, which is absolute ownership. They could have a life estate followed by a remainder man. A life estate is when, an owner has full use of property during the duration of their life, and then after it'll go to another party, a remainder man. The life estate tenant has the duty not to commit waste, just like a regular tenant has that duty not to commit waste, and they have to pay taxes and interest on the mortgage. The remainder man has to pay the principal of the mortgage. I'm going to kind of skip over the Shelley rule, word of your title, rule against perpetuities thing. I mean, I could talk about it more maybe next class, but rule against perpetuities, it's actually been changed to 1,000 years now in Florida, but it's just like, we can't have property that's just going to linger. It has to actually vest within a measuring life. But I'll talk about that more next class if we even get to that. I've only seen rule against perpetuities come up one essay one time, and it was actually a trust essay. Just I won't talk about today. All right, joint tenancies. So joint tenancies with right of survivorship versus tenancy in common versus tenancy by entirety. These things come up a lot. You got to be pretty confident in the different types of tenancies. A JTROS is when each tenant automatically owns 100% of the asset when the other tenant passes away. In other words, the tenants survive each other. So JTRS, Tommy and Johnny, Tommy passes away, Johnny takes the entire property. Johnny survives Tommy. In order to have a JTRS, we need to have the elements of TTIP, time, title, interest, and possession. This means that the parties taking interest in the property must take the interest at the same time by the same title with the same interest in the property and have equal possession to the property. Additionally, specific language must be found in the deed in order to create a joint tenancy, such as with the rights of survivorship. Without that specific language, Florida law assumes the creation of a tenancy in common. So tenancy in common is assumed, but if they intend to create a JTROS, they have to use those, words with rights of survivorship. And a JTROS must have the unities of time, title, interest, and possession. A tenants in common is just when A and B are, living together, whatever, they have equal rights. B passes away, and then B's heirs or descendants will take B's part of the property instead of A surviving B. That's the default form. And then a tenancy by entirety, a TBE, is essentially a JTROS plus the element of marriage. Florida has abolished the need for a straw man. A straw man is a third party that historically, when you wanted to create a JTROS, let's say between a married couple, well, what if Andrew had a townhouse in Coconut Grove and then he found the love of his life, Susie, and I was like, hey, Susie, come live with me. We'll have this JTRS and we'll make it a tenancy by entirety. It's going to be amazing. Let's get married. And then it's like, okay, but there's a problem. Does anyone know what the problem is? There's not that unity of time. She didn't take the townhouse at the same time I took it. I took it in 2016. She just took it today in 2025. That's not the same time. So historically, I would have to actually convey the property to a straw man, a third party. The straw man would reconvey it back to me and Susie, right? And then me and Susie would have a JTROS plus marriage tenancy by entirety. Florida has eliminated that need for a straw man. In Florida, if I marry Susie and I intend to bring her on as a JTROS, then there's no need for a straw man. We can just create a tenancy by entirety simply through recordation. Okay. Covenants and equitable servitudes. So equitable servitudes differ from covenants in that they're enforceable by injunction, while real covenant is remedied by money damages. No horizontal or vertical privity is required for an equitable servitude to run with the land. Servitudes are ownership interest in the land, while real covenants are promises. I mean, the main difference between an equitable servitude and a real covenant is the remedy. Equitable servitudes, like they sound like, are remedied by equitable relief, injunction. Real covenants are remedied by monetary relief. So an example of an equitable servitude I use is like in my townhouse association, we all have to paint the doors blue, like grease or something, right? And if I painted my door red, what would they say? Ding, 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 Andrew, you need to paint it back blue. That's a equitable relief. Now, if there was like something that said like anyone who, leaves parking or who parks in someone else's spot has to pay a fine of $50, that would be a real covenant because it's monetary relief. If they said anyone who lives in my townhouse development has to vote, for a particular political candidate, that would not touch and concern the land, and it wouldn't be enforceable to run with the land. To establish a valid and enforceable covenant running with the land, the plaintiff must show that the existence of a covenant that touches and concerns the land, an intention that the covenant run with the land, and notice of the restriction on the part of the party whom enforcement is sought. Further, for the covenant, there must be, and this has been a little bit relaxed, but privity, meaning privity between the original parties, which is horizontal privity, and privy between the subsequent parties, which would be vertical privity. They've really relaxed that element in enforcing covenants, so I won't even get into that conversation about the burden and the benefit. But just at a general level, if you can just understand, oh, this is a real covenant, this is an equitable servitude, it runs with the land, the subsequent party will be, bound by it based on whether there was notice, intent, and it touched and concerned the land. Just stick with me all. I've got like probably 10 more minutes and we'll call it a night. Landlord and tenants. So, yeah, Rosie, you want to go for a walk too? I know. So lease for a term greater than 1 year. A writing is required and must be signed by the lessor in the presence of 2 subscribing witnesses. Yeah, I guess for land sale, it needs to be in writing. A lease under 1 year doesn't need to be in writing. A non-residential tenancy at will. So these pieces we'll go over, but pretty much it's landlord tenant duties. And if there is a tenancy at will or a periodic tenancy or whatever it may be, there's notice requirements for termination. The mnemonic that we use is your period will suffer. Tenancy at will, tenancy for years, periodic tenancy, tenancy at will, and tenancy at sufferance. A tenancy at years is for a specified period of time. A periodic tenancy is like a week to week or month to month or a repeating tenancy. A tenancy at will means either party can end it at any time. And then a tenancy at sufferance is like a holdover tenant. So the lessor duties, the lessor must deliver possession of the premises, allow the lessee quiet enjoyment of the premises, and maintain the premises as habitable. Further, they have the duties of extermination, lock and keys, clean and safe common areas, garbage removal, running water, hot water, and structural repairs. These duties may be altered or modified in writing. So the big duties of the lessor are habitability and quiet enjoyment. That word quiet enjoyment you saw as one of the covenants or warranties of a general warranty deed. It's also one of the duties of a lessor. So habitability and quiet enjoyment. Habitability meaning that it's livable, quiet enjoyment meaning there's no intrusion from either third parties or the landlord himself. The landlord can't just walk in his bathrobe while you're, watching football on Sunday, right? Florida does require the actual delivery of the premises, not just the legal delivery. So they're responsible if there's a holdover tenant. The lessee has a duty to pay rent and not commit waste. Additionally, the lessee must comply with the health code, keep the premises clean, keep plumbing in good repair, remove garbage, use plumbing and electrical equipment carefully, refrain from disturbing neighbors, and not destroy the premises. Hugely tested in this domain, whether it's a life estate tenant or, a tenant for, a landlord tenant issue, is the doctrine of waste. And there's 3 types of waste. Actual waste, which is like actual or affirmative or voluntary waste, like punching a hole in the wall. Permissive waste, which is like letting things rot, like you see there's something dripping and instead of like cleaning it up, you just permit it to continue wasting. And then ameliorative waste. And you'll see, I'll give you guys a little hint on the essay you're going to write. This lady commits ameliorative waste. I think it's the lawyer, by building offices on the property. Even though it improves the value of the property, she's still liable for removing those offices because no one asked her to do it, right? That's ameliorative waste. And then there's abandonment of the premises. Abandonment occurs when the lessee is absent for 30 days, coupled with non-payment of rent. If a lessor obtains a writ of possession, she may repossess and give up the right to collect rent, wait and sue for unpaid rent, or re-enter the premises on behalf of lessee and hold lessee liable for any loss. So there's like a constructive eviction where the landlord makes it untenable and the tenant actually moves out. You can claim a constructive eviction. There's abandonment if, they leave and don't pay. There's all these different things. And then Florida does not permit self-help, removing a breaching lessor in a landlord-tenant relationship. In Florida, you have to actually evict the tenant and you have to get the, what do we call this guy? The sheriff to come remove them. All right, let's talk about easements. So easements is another question I love to ask people. What are the different types of easements? Express versus implied. Express easement is created when parties agree to allow a dominant estate a specific use on a serving estate. A person using express easement beyond the stated use is liable for surcharge for the value of the overuse. That's a good word. Remember when we talked about mortgages, I taught y'all a good word, which was, what was it? Does anyone remember? If they have to collect personally because the foreclosure sale is not enough to pay back the mortgagee. Rosie, come here.
Deficiency judgment.
Yeah,
Deficiency judgment.
deficiency judgment, right? Making sure you're all learning. Rosie, come here. And then this good word right here is a surcharge. A surcharge is what someone is liable for overuse of an easement. So if someone overuses an easement, that doesn't terminate the easement. It just gives rise to a surcharge, which is a payment for overuse, right? All right, so express easement is written and implied easement if there's initial unity of ownership, severance of that unity, and requisite degree of necessity. So an implied easement could be like a easement by necessity, right? Is an example of an implied easement. It's just some sort of situation where it wasn't expressly granted, but easement is implied to exist. So express or implied is the first prong. Then there's easement by necessity. So the statutory easement by necessity means that the claimant must show that the parcel is located outside municipality, that she used her parcel for agricultural purposes, and the land is so hemmed in that there's no reasonable route of entry or exit without the easement. There's no need to prove unity of title from a common source. That's a statutory easement by necessity. On an essay, there's still the, common law easement by necessity that you could argue for, right? That they're just, they have no access to a public road. A prescriptive easement, it's similar to adverse possession. Statute of limitations is 20 years and there's no need to prove exclusivity. So when I say similar to adverse possession, the mnemonic I use for adverse possession is ocean. Open, continuous, exclusive, adverse, notorious, and for the statutory period. Very similar, open, continuous, adverse, notorious, and statutory period, but it doesn't need to be exclusive. Why does a prescriptive easement not need to be exclusive? Because multiple people could have the same right of access, right? Like Tommy and Johnny could have the same prescriptive easement, but Tommy and Johnny, unless they were, a party together, could not have the same adverse possession claim. All right, so we have express, implied, easement by necessity, prescriptive easement, a pertinent easement, and easement in gross. So easement appurtenant, it takes two, right? You guys know that song? It Takes Two by the lady who invented rigatoni or something. An appurtenant easement allows property owners to access land that is only accessible through a neighbor's land. Conversely, an easement in gross benefits an individual or legal entity rather than a dominant estate. In Florida, an easement in gross is considered personal to the original holder. I'm sorry, she invented vodka, penne alla vodka or something. But appurtenant easement means like there's two parties, a dominant and a servant estate. That's the easement appurtenant. Easement in gross means that it's like personal. It's like the utility company putting a utility pole in your property. Easement appurtenant will run with the land, right? That if A and B, B has an easement appurtenant, and then B sells to C, it'll run with the land. That's what easement appurtenant means. And then a negative easement, Florida recognizes negative easement for riparian rights, but not for light, air, and lateral subjacent support, right? Okay. Adverse possession. So I talked about this a little bit earlier. Ocean is the mnemonic, open, continuous, exclusive, adverse, notorious. All that means hostile. It's the statutory period. It's going to be 7 years. So for real property, 7 years. Maybe Nat, are you still there? Maybe she left, but she said
I'm here.
that's probably what your overlord was talking about, that 20 years at common law for adverse possession. But Florida, if you were watching an MBE video, Florida, it's 7 years for adverse possession, 20 years for prescriptive easement. But the numbers aren't that really important. All right, so the claim under color of title, the claim must show that the land has been cultivated, improved, or enclosed. If the land is not enclosed, the possessor must show that it's used for food, timber, for the ordinary purpose of the possessor. So that means you have some, document or deed purporting title. If you don't have color of title, they must show the property has been protected by substantial enclosure, has been usually cultivated or improved, and payment of taxes also required. So I talked about that earlier. Hopefully this reinforces it. Not supremely important, but just like the more you know, right? 7 years for adverse possession in Florida, 20 years for prescriptive easement. For personal property, adverse possession claim would be 4 years from the time the cause of action accrues. So homestead exemption, I talk about it in common law, I talk about in real property. It's talked about twice because it's supremely important, right? I'll read it just so y'all can hear it again. Article 10, Section 4 of the Florida Constitution sets forth the homestead exemption. It states that there shall be exempt from forced sale under process of any court, and no judgment, decree, or execution shall be a lien thereon, except for payment of taxes and assessments thereon, obligations contracted for the purchase, improvement, or repair thereof, or obligations contracted for house, field, or other labor performed on the realty, the following property owned by a natural person. So they're just saying like, those are the exceptions. Those are the people who can pierce homestead. Uncle Tom, I'm sorry, so fucking sorry. Uncle fucking Sam, scratch that. Uncle Sam, meaning the government taxes. That's not funny. I mean, Uncle Sam, like the government taxes can pierce it, government judgments taxes, and then anything that has to do with the property itself, like mortgages or liens or homeowners association or a lawyer who defends the homestead, like obligations on the property itself. Those are the exceptions. Anyone else, any other judgment creditor, cannot pierce, meaning that the homestead, if located outside municipality to the extent of 160 contiguous acres, and if within a municipality to the extent of 1/2 of acre, are exempt from judgment creditor, right? So that's what the homestead exemption is for. It protects your primary residence from outside creditors, 1/2 an acre inside municipality, 160 contiguous acres outside municipality, and the exceptions are, government judgment and taxes, and then mechanics liens, construction liens, mortgages, homeowner association fees, condo fees, assessments on the property itself. All right, and finally, and I know, there's a lot to cover real property. I think I tell people this, I think common law is the widest, the most material, but I think real property is the most difficult, if that makes sense. That's just my personal opinion that like, contracts and torts are pretty straightforward. Common law is so much that's tested, and then real property is actually really difficult. And then, family laws, I don't want to say anything's easy, but like it's not the worst. And then ethics, I have a pretty good formula that we can be confident with. But let's finish strong with miscellaneous. So Florida's a lien theory state. A joint tenancy with right of survivorship allows either party to encumber their interest in the land as they wish. This means that either party may take out a mortgage and use their interest in the land as collateral, or may allow creditors to place a lien on the property. However, such an encumbrance does not alter the other party's interest in the JTRS. It will not sever it. Additionally, in lien theory states, because an encumbrance placed on the land by one member of the JTRS does not hinder the other holder's interest, if the encumbered holder dies before paying back the mortgage or the lien, the creditor cannot collect from the unencumbered holder. In summary, since Florida is a lien theory state, a mortgage on the property does not sever a JTROS. That's some key facts right there. I know this is a really boring lecture tonight, but like I have been saying some really key things, and that's one of them. In a lien theory state, a mortgage will not sever a JTROS. So the risk of loss, Florida follows the majority rule, which places the risk of loss on the purchaser on the execution of a binding contract for the sale of land. We call that concept equitable conversion. Under the theory of equitable conversion, the risk of loss passes to the buyer after the contract is signed, before the closing, during the period of escrow. Eminent domain must be a full compensation for its highest and best use. So private property taken after 2007 may not be conveyed to a natural person or private entity without passing a vote from 3/5 of each house of the legislature. Fair enough. So eminent domain takings, it comes from the Fifth Amendment, condemnation, just compensation. These are all concepts with takings clause. Public nuisance, defined as any building or place which tends to annoy the community or injure the health of the community. The Attorney General or other qualified actor may sue in the name of the state if the nuisance reasonably annoys the community. So a private nuisance is a tort, right? And a public nuisance is brought by the Attorney General when it's annoying to everyone in the community. A private nuisance is brought by a private individual when it's a more individualized complaint. And then nuisance abatement. Abatement or elimination of a public nuisance is not a valid public purpose for which eminent domain may properly be exercised. So just because you have some annoying thing on your property doesn't mean that the state can take your property. They can just force you to stop the nuisance. Okay, so here's some practice essays that we gave, and this one you could see there's like a pond, there's a adjacent property. So this one's about easements. You definitely I remember you want to write about surcharge here, and talks about mortgages. I'm going to talk a lot more about mortgages in a second lecture. That's why I do 2 lectures for these subjects, because there's still a lot more to talk about. I think a lot more details I could get into, but that's what this essay seemed to be about, was like an easement and a mortgage, probably pure notice jurisdiction and things like that, and maybe even like a misrepresentation claim or some tort element. And then this is the one that you guys are actually assigned to write. This is the one that I took during my year, and it's a really tough essay. And you'll see that there is one part where they take out a tax deed, right? 2 years later, she applies for and receives a tax deed. Everyone was like, what is a tax deed? So, don't get alarmed on test day if there's some weird subject or topic that you're not prepared for. Hopefully after taking my course, you're prepared for everything and anything, but it was tough. This one also talks about a partition. I didn't really mention what a partition is. So a partition is, a split of the property. There can either be a physical partition or there could be a judicial partition, which is a sale and a split of the proceeds. But one thing to remember is that remainder men cannot ask for a partition until they've received the property. A partition is for the current owners of the property. And then this one seemed to be about, something being sold as is. This is gonna be that Johnson v. Davis, duty to disclose, gonna have some contract elements to it. Things like that. So I really encourage people to go through the essays. We'll do it on the workshop. We're gonna have a whole nother lecture on Wednesday where I go over a lot more of these things. We'll go over the questionnaire and some outlines and stuff. But I think those are the good PowerPoints to just kind of get started. Remember, it's about deeds and titles, property interest, joint tenancies, covenants, equitable servitudes, landlord tenants, easements, adverse possession, homestead exemption, and then some miscellaneous things. Key takeaways from today: Florida is a lien theory state. Florida is a pure notice jurisdiction. We like the word deficiency judgment when they can't pay off the mortgage from the foreclosure. And we like that word surcharge when there's been an overuse of an easement. So I think there's a motivational quote on this one. I know I used to do motivational quotes. Let's see what we got. Oh man, nothing. All right, never mind. The motivational quote, Nat, you got anything for us? You want to quote your Jimmy Butler, maybe? When times get tough, just quit. No, I'm just kidding. That's not the quote.
Yeah, when the going gets tough, the tough get going.
When the going gets tough, the tough get going. That's amazing. And I really appreciate y'all. So why don't you get going on your studies? We'll be back Wednesday for real property. Tomorrow I'm doing real property for the MBE. And we're in that window where you really want to study hard and lock in. So I'm going to go ahead and stop this recording.